Howdy, and welcome to the show. Cooper's Code examines a legal issue and hits the highlights so we all achieve the best results for our clients. I'm Miles Cooper, and with today's guest, Andrea Posey, a partner at Cooper's, we will be discussing working with witnesses to make sure they are ready to withstand the rigors of testifying at trial. Before we get into today's topic, a few words about Cooper's LLP. We at Cooper's are committed to thought leadership, developing the best talent, and honing skills through learning, practice, trial, and the relentless pursuit of justice for consumers. With lawyers licensed in California, Oregon, and Washington, we're available for free strategic consultation on cases, and we accept referrals, trial, co-counsel opportunities. For more information, visit our website at coopers.law or email us at podcast@coopers.law. Welcome back to the show, Andrea.
Hi, Miles. Thank you for having me.
It's nice to have you again. As one gets ready for trial, there are so many things that one has to do in order to make sure that the show goes on effectively. One of those is making sure that witnesses, whether they be client, expert, but really I would say this particular episode is geared towards the layperson witness, to make sure that person is ready for trial. How do you initially start going about that practice in terms of making sure that the person's actually going to show up and that the person is ready to be there and not, say, cause a mistrial or some other issue in the case?
So I like to contact the witness, but then stay in contact with them often. Let them know, yes, the case is still going. Let them know when we expect that we will need them. Let them know the logistics, time, date. Let them know it likely we will not need them on the first day, but that we need to get their availability for the next week or two afterwards, and we will do the best to accommodate their schedule. But stay in contact with them early and prepare with them early.
I understand as lawyers, we have the subpoena power. Don't you just issue a subpoena and the witness willingly says, oh, I understand the power of the court. I'm totally willing to show up. Does that not happen?
No. And I would not go to that step right out of the gate. No one likes to have a process server come up to their door and hand them a legal paper that is ordering them to be somewhere. You don't want them to be coming in as a hostile witness. So I would reach out to them, be friendly, be courteous, let them know that we don't want to inconvenience them with having a process server show up at, all hours. See if they will be willing to accept the subpoena by email and just acknowledge receipt of it. But you do want to have a subpoena, even if it is a friendly witness, because if they're on the stand and they're asked about it, we don't want to make it seem like they're our witness. We want them to be able to say, yes, I know this person, I'm friends with this person, or I work with this person, but I'm also here because I received a subpoena to be here for trial. Most of them will be appreciative that you're trying to be accommodating, but always send a subpoena.
In addition to a subpoena, do you ever use what some people refer to as a standby letter? I know you mentioned you'll let a witness know that they're not needed the first day, but do you use something to sign off on so that they know that while the subpoena says to be there on Monday, you don't need to be there Monday, you're on standby?
Yes. With the subpoena, we always do a letter, and I also call it an on-call agreement. And it's an agreement from the witness that they know they don't have to be there the first day, but they need to give us their availability and agree to be on standby. Try to give them as much notice as possible, but give us your cell phone numbers, the best contact information, and let us know when you are available, and we'll do our best to have you scheduled.
While a lot of what we're talking about here is helping a witness be ready for trial, some of what we're talking about too is helping a witness actually be willing to go to trial. And I know you had a lot of challenges with certain witnesses in our most recent case. And maybe you can explain a little bit about the kind of work that you needed to do to help people who, even though they might be under subpoena power, were saying, gosh, I really don't want to be there. How did you deal with that?
This particular witness that you're talking about, she witnessed a prior crash. So not even our crash that we're there for the trial. She witnessed a prior crash, and it was relevant because we were showing the history of this driver. So the prior crash that she witnessed was years ago. And in her mind, she's like, I don't know the people that are on this subpoena that you're talking about. I have nothing to do with your case. I already gave my statement to the police. This is inconvenient for me. I don't want to be there. And I totally understand that. She's getting a call from an attorney out of the blue. But I explained to her that she doesn't know the logistics and the legalities of getting evidence in at trial. And I explained to her that while we appreciate that she already gave her statement to the police, We can't just simply introduce the police report at trial as evidence. It's important to have her come into trial. Fortunately, I was able to pull some strings and see if I could get her to agree to appear by Zoom to make it even more convenient for her. But I told her the importance of just telling the jury what she saw. That was it. It would be quick. It would probably be a half an hour out of her day. We'll make it convenient and do it by Zoom. But it's important to our case for her to say just what she saw in it. And I think when I explained to her and she saw that I was trying to make it convenient and letting her know why we needed her testimony as opposed to just submitting her statement, she seemed to understand and she was compassionate for our client.
As we talk through ways of getting witnesses to trial, it does seem like a lot of courtrooms have embraced Zoom. Some actually are Zoom forward. We've talked a little bit about Alameda County, where oftentimes they prefer to have a Zoom witness as opposed to a live witness.
Yes.
Have you found that the ability to use Zoom in a courtroom has made it easier as you're negotiating with witnesses to be present?
Very much so. Everybody has very busy lives nowadays, and I get that. She had commitments as far as helping her grandchildren, things of that nature. And I think if we can make it convenient for them, you don't even have to leave home or leave your office. You can just log on for half an hour, and that makes a big difference. And I think it also takes kind of the fear out of appearing at a courthouse, which is very intimidating for people that don't do it every day. And especially when she doesn't have a stake in the case. You know, she's not there trying to hold anybody accountable or anything like that. She has no dog in the fight, and she doesn't really want to be there. So I need to explain to her what the importance of her being there is, the reason that we need her, and try to make it as convenient as possible for her.
All things being equal, do you prefer a Zoom witness or a live witness?
Always live.
Why?
For me, I know what the testimony is likely going to be, but I think it's important for the jury to see that person live. And things could not go the way that you plan. And I think that it's easy to pivot if you need to, if you're there in person. And I think to have the interaction of being there in person with everybody live, the witness live, just seeing the whites of each other's eyes and having the jury see their facial expressions, things like that, having the witness see your client sitting there, all of those things I think are important. It's more entertaining for the jury. It's more interactive than just watching the TV screen.
The other piece that I had not really considered in terms of logistical issues with a Zoom witness is dealing with exhibits in terms of being able to, say, impeach an expert or do something else where if the witness goes sideways and you need to be able to use an exhibit to do it, it is much harder when there's a Zoom component involved.
It's the hybrid dynamic. I mean, when we're on a deposition and we're all on Zoom, you can share your screen, drop things into the chat. But you're right. When we're all in the courtroom, we're not on computers. I don't even think we even used any exhibits with witnesses that were on Zoom for our trial because it's very difficult to do. It is a hindrance, I think, for trial.
We intimated that we had lots of exhibits with an expert who suddenly developed COVID and did not show up in person. But
yes,
we, in essence, had to bluff with that.
And actually, it worked because sometimes, like you said, we are pulling those exhibits up for the reaction with the jury. For instance, taking out 2 bankers' boxes of depositions and setting them down on the table had a significant impact for the jury, even though the expert on the TV screen couldn't really see it.
To tie that one up so people understand, that is exactly what we did. This was an expert who was notorious for saying all of the changes are pre-existing and there's no indication of trauma based on the imaging. People can probably guess who this radiologist is. And we managed to find, I think, 36 depositions where he had previously testified exactly the same.
And so sometimes it's just for the impact on the jury and not for the witness.
Yeah. Going back to witness preparation, whether it's Zoom or in person, as you are helping the potential witness be comfortable, and at its root, I mean, that is what you're trying to do, right?
Yep.
As you're helping them be comfortable, what steps do you take in terms of talking them through the expectation process? And that's one question. And then, because I like compound questions, the other one is, what steps do you do to make sure that they don't create challenges in the case? Say, for example, being unaware of motions in limine or references to insurance or chatting up a juror in the hallway. kind of walk me through your prep process to make sure that they provide the best testimony possible?
Sure. Kind of from a logistical standpoint, like you said, start with the basics. Let them know what's expected, whether they have to be there in person, whether they can appear by Zoom, when they need to be there, things of that nature, what they need to look like, their attire. If they're going to be there in person, let them know that they can't just walk right into the courtroom. Let them know how they should conduct themselves, that they should wait outside, someone will come and get them. Let them know what to expect when they enter the courtroom. All of these eyes are going to be on them. Give them all of the details so that they remain comfortable from the moment they leave their home till they walk out of the courthouse. Give them all of that information. If they're going to be by Zoom, let them know what they can expect to see on their end, what they can expect to hear. And then I think it's also important they don't know what's gone on in the trial up to this point. You mentioned motions in limine. It's our job to make sure that we educate them and let them know what they can talk about, what they can't talk about. For instance, insurance. We don't want them to go on about insurance when we know that there's been a motion in limine for that, and the other side will create a big fuss. So we need to make sure they're prepared for content also. I like to do either a call or a Zoom with the witness beforehand, and I will kind of do a dry run. I will have my questions. I will also throw in some questions that I think the other side will ask. And one of the most important things we tell our clients, we tell experts, we remind witnesses that keep the same demeanor that you have when I'm asking you questions or someone from the plaintiff side is asking you questions as you do with the other side. You want to be respectful. You want to answer the question, because if you change that and you get a little argumentative on the other side, the jury will pick up on that. And we don't want them to seem like they are our witness. We want them to be a lay witness, a neutral witness. I think it's important to prepare with them, run through the questions, give them an idea of what's going to be asked of them, what they're there for. And then importantly, ask them what questions they have. Sometimes they have a ton of questions, sometimes they don't. Later, as it gets closer, they may have more questions. So make sure to reach out to them, let them know they can contact you anytime you want them to be comfortable coming into it.
Do you also provide them with some indication of, I might call it stage direction, that you might be providing to them when asking them questions? For example, a lot of times we're looking for a witness to make sure that they're communicating in a meaningful way with the jury. And if they do feel comfortable turning and talking to the jury, these are 12 people who want to make the right choice. If you are willing to speak to them, by speak to them meaning not just having a conversation between the lawyer at the lectern and the witness, but to turn to the jury and speak. I sometimes will say something like, will you tell us, and then I will gesture towards the jury, tell us what you saw that day. That's the kind of thing where I'm looking for you, if you're comfortable, to speak to the jury instead of just speaking to me.
Yeah, I mean, we have an idea of what they're going to say, but these 12 people want to understand everything that's going into this case. They're there to hear from who's on the witness stand, expert, party, everybody.
A lot of these witnesses that we're talking about are what are known as cameo or collateral or character witnesses, where they're there to talk a little bit about the person who was hurt. This is what this person was like before. This is how they're different. And the challenge I find with those types of witnesses is you can do all the preparation beforehand, and then they come into the courtroom, and I would say about 1 out of 4 freeze, meaning this person who was articulate, warm, friendly, kind, was going to be able to outline the big differences between how the client was before and how the client was after. They come into this big room with somebody in a black robe sitting high up, 12 strangers staring at them. They take an oath, and then all of a sudden they become, yes, no. And I will sometimes let them know that this is natural. It may happen to you. And if that's the case, it's my job to help you break through that. And I may ask you a question like, are you nervous? Yes. Why is that? Do you do this on a regular basis? I do not. Okay. Well, let's just go through it. Do you have tools or other things that you do with witnesses to help them have some expectation that it may not go according to plan, even if they think everything is going to be fine?
Yes. I mean, obviously the preparation helps, giving them an idea of what to expect. But you're right. Until you're actually in there, you don't really know how it's going to be. And there may be times when they freeze up, but I think it's our job to kind of start with the softball questions and start to get them comfortable. And I think most of the time, if you help them with some softer questions, once they get going, they're usually okay. It's just initially, it's very intimidating. The more we can do with kind of the soft questions, feeding it to them, the better. So we should be prepared for that.
As you're working with the witness to make sure that the witness is comfortable with the whole process, and I want to be clear, when we're talking about having a witness prepared for trial, I think there's some people who might take this away as these are lawyers manipulating the facts and making sure that the story that they want told is the story that comes in the courtroom. I've always thought of preparing a witness as making sure that they are so comfortable with the process that their nerves, fear, all the things that come along with court and judges and the justice system don't interfere with their ability to communicate. It's that level of preparation. You highlighted a key point, which is maintain the same demeanor with me as you do with the opposing counsel. They're doing their job, and opposing counsel, this particular one is nice, or this particular one can be a little heavy-handed. Even if they're being rude, mean, it's not your job to be mean back. These are generally the areas where I'm thinking they may go with you. For example, you are the mother of this client. They're going to go to bias, and they may just ask one question. You love your son very much, don't you? Yes. You want what's best for him no matter what? Yes. No further questions. With that kind of as a backdrop, are there things that you do to help kind of telegraph the directions the defense counsel may go in the case? And I'm giving you this information so that when it goes that direction, you're ready for it.
Yes. As I mentioned, having kind of a list of questions for information that we want them to portray to the jury. We also have to probably have a list of questions of what we expect the defense to do and kind of do the dry run with them with the hard questions. Let them know that we're going to get tough because we want them to be aware of that heading into it. Then I think they're not as surprised. But, let them know you're here to tell the truth. Stay calm. If you don't understand a question, you can go ahead and tell them that. Let them know that they're not there to be beat up on and that they just need to tell the truth and do the best they can.
With an individual who has had their deposition taken, what extra steps need to be done with that witness in terms of making sure that they have their deposition, not just got it 6 months ago, but have gotten it recently, and that one is certain that they've at least read through it a couple of times so that they don't inadvertently contradict themselves?
Yes, I think if they've given any sort of statements, whether it's in a traffic collision report, whether it's in a deposition, it's very important that they're consistent. And if there's a substantial gap in time from when they gave their statement in a traffic collision report or even when they were deposed, give them a copy of that and tell them to review it because they may not intend to give conflicting testimony. But if a long time has gone by, a lot of life has happened in that period. And there's no quicker way to lose a witness or an expert with a jury than someone who gets caught contradicting themselves. So you want them to really remember how they testified before and be consistent with that.
You did a nice job of talking about how you need to let the witness know that they need to wait in the hall. Somebody's going to come and get them. Then there's also the other issue. They're finished testifying. And this is always, I will confess, this is one of the more foreign feelings for me. Usually, I want to thank somebody for what they've done, an expert, a witness, what have you. Thanks for coming in. A courtroom is so foreign in that environment. Do you prepare a witness for that so that they don't inadvertently come over and shake your hand or high-five you or do something that might look awkward in front of a jury?
Yes. And like you said, it's difficult for us because we're used to being friendly with people. It's customary when someone comes in and goes out of their way to testify for us that you want to shake their hand and tell them, thank you for being here. On behalf of our client, we're so appreciative. We appreciate your time. But we can't do that because we don't want it to seem like that witness is our witness. So I'll let them know ahead of time, thank you so much for agreeing to be there. I really appreciate it. Thank you on behalf of our client. I'm happy to give you a call after this and let you know how it goes. But just thank them ahead of time and let them know, I'm not being standoffish if I don't say goodbye or smile or shake your hand afterwards. We just always need to keep decorum in the courtroom. And, I need to keep a good demeanor and not give any sort of perception of impropriety.
You talked about letting them know that you'll reach out after the case is done, or perhaps after the testimony is done, in terms of, thanks for coming in today. I want to give you feedback. The jurors seemed very receptive. How do you stage your post-testimony communications with a witness?
Most of the time, I'll wait until the case is done, because I feel like once witnesses and experts have come in and done their job, they always want to know that they did a good job. Even if they didn't, they feel like they've done something good, and they have. I always want to be able to let them know the outcome, because that's always a question that comes up. So most of the time we have to wait until the trial's done. And then depending on what my usual communication is, I will usually just pick up the phone and call them, because I've been talking to them a lot leading up to it. So I like to have a conversation with them, thank them again for coming in, let them know that they did a good job, that the jury appreciated them being there and listened to all of their testimony, and let them know the outcome of the case, because they're always curious.
And I think one of the things that you didn't say in terms of talking by phone that deserves being said is, even if the case is done, a verdict has come in, it doesn't mean that there's no motion for new trial, no appeal, no nothing. And so any communication you're going to have with a witness post-verdict, you still want to have that communication in a way where you recognize it might be discoverable. Meaning a text message that says, "We're so glad you came in, you totally hit it out of the park," whatever it is, something that's going to not look good if the defense ends up subpoenaing.
That's always important. I always try to think witnesses will ask a ton of information, and you want to give them that information, but sometimes it's not always appropriate. Be careful of that, but try to give them a follow-up. They're going to be wondering, they're kind of invested at that point.
Interestingly enough, while this has not been geared towards experts, I get more communication from experts, and sometimes a text like, "Tell me how I did." Hell no. I mean, I might pick up the phone and give you some feedback on, this is what was effective with a jury, this is what was less effective. But I am certainly not putting in writing with an expert that I may be working with in the future about what's going on.
Yep. All that stuff is potentially discoverable. So always keep that in the back of your mind.
We've talked a lot about witness prep for trial. Are there other pieces that you think are important for people to know about in terms of getting a witness comfortable with the process and invested to the point where they're willing to show up?
I think reaching out early in the case, whether it's a witness that you come across in the traffic collision report, whether it's, as you mentioned, cameo witnesses, family, friends, get your client thinking about those people that can talk about the before and after, but reach out to these people early on. That way it's not 3 years after a crash or something of that nature, and they're trying to remember all of these things. Let them know when it's more fresh in their mind and get them kind of on board with the case, I think is crucial to keeping them happy during the case. And that's what we want.
Well, as always, thank you for being here, Andrea.
Thank you for having me.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions on how you work with witnesses to make sure that they are ready for trial. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.